any agreement, an agreement which is enforceable by law is called as contract, not expressively declared void. So it is not something which has already been declared void, it's something which can be done. Whatever I am offering to you must be legal in nature. I should not offer you something which is illegal or against the society, against the norms of the business. Good morning and welcome to the first session in commercial law, where we are going to speak about a very important topic called as the contract. Before we start stepping into the subject, commercial law is a very interesting topic, interesting subject altogether, where we are going to learn the different terms and definitions in this subject. So let's just go further and try to explore the various features and topics that are available in the unit 1. So starting here, let's go on with the introduction of the commercial law and how did it come into picture. So the first thing is about the Indian Contract Act, which started in the year 1872, and this is the law that is related to the contracts in India. Now, just going back in history, India is a country that was dominated by the British for almost 3 centuries, more than 3 centuries to be precise. So most of the law regarding the trade agreement contracts were framed using the British icon and ideologies. So that's why when we look at the Indian Contract Act in the year 1872, which signifies very clearly here that all these laws, all these contracts were formed long time back, and these were all the systems that were used in a very old manner, in an old tradition altogether. Then it came into force on September 1st, 1872, and it was extended to the whole of India, including the state of Jammu and Kashmir. So in the year 1872, on September 1st, this law was brought into force, was brought into action, including the state of Jammu and Kashmir. Why I'm mentioning it is that there have been several places or instances where you would say that J&K, Jammu and Kashmir, has not been included, but in this case, in this particular law, it is including both that states altogether. Now, going further, we are also going to understand that this act has got 266 sections altogether. So there are totally 266 sections which are available under this particular Contract Act. Now, moving further, important definitions that we are going to learn for today. The first one is called as offer, which comes under the section 2A. What is the definition for offer? When one person signifies to another his willingness to do or to abstain from doing anything with a view of obtaining the assent that other to such act or abstinence, he is said to make a proposal. Let's first try to understand in simple terms what is the meaning of an offer. When somebody comes to you and offers you a proposal, an idea, a business suggestion, a solution, what do you tend to do is that you have two factors, two options with you. Either you accept it or you reject it. So similarly, offer is something where a person is being given a position, given a chance where he signifies, where he says whether I am willing, whether I am accepting to do it or I am rejecting from that. Whatever might be the terms and conditions, we will go into it later. But the initial standpoint is that whether I am interested to take up the offer and do it, or I am feeling that, sir, this cannot be done by me. Why should I take up the risk of doing it? I am not interested in doing it. so let me just reject it altogether. So in that case also the offer comes into picture. Now this depends upon what kind of offer, when it is offered, what are the factors, what are the terms and conditions. So based on that, the proposal will be taken forward. So the first thing that one has to understand when it comes to the word contract is that it actually tries to give in first a position to the person, saying that whether he is interested or not in taking up that particular activity altogether. Moving further, now let's talk about acceptance. What is the meaning of acceptance? When the person to whom the proposal is made. Now, since this is being a law paper, we need to follow each and every word that is being prescribed in the textbook as it is. Please do not try to deviate away from the context. So whenever I'm trying to make you explain about the terms and conditions, let's go word by word to understand the meaning and significance. So here, coming back on acceptance, when the person to whom the proposal is made, so you are the person and I am making a proposal. Now, when the person, that is you, signifies his assent, which means you wholeheartedly accept the proposal thereto, then the proposal is said to be accepted. So, when I make an offer to you and you are accepting the offer wholeheartedly, that's where the word assent is coming into picture. Then the offer is said to be accepted. Now, the next thing, promise. Now, we use this word promise very, very commonly in our life. So, whenever we were small kids, so whenever people used to ask you, promise from tomorrow you will do your homework, then we used to say, yes, promise, we will do it. Now, that kind of promise is not what we are looking here in terms of commercial law. The word promise here has got a significant meaning or an importance here. What does the word promise mean according to section 2B? A proposal when accepted becomes a promise. So when I gave you the offer and when you accepted the offer, now that offer has become a proposal. The proposal becomes a promise. In simple words, when an offer is accepted, so when I gave the offer to you and you have accepted the offer, it becomes a promise. Why it becomes a promise? Because now you have accepted to the terms and conditions, which means to say that you will execute the offer as per the terms and conditions that are prescribed. So that is what I mean by saying here, the offer now becomes a promise altogether. So you are going to enact, you are going to follow the rules and regulations which are set in the offer. Now going further, Promisor and promisee. Now these are two new words that you are going to learn today from the aspect of commercial law. Where does this word come in from? Promisor and promisee has been mentioned in section 2, subsection C, where we say when the proposal is accepted. The person making the proposal is called promisor. Here I am the promisor who is making the proposal to you, and the person who is accepting, that is you, is called as the promisee. So let's again look into the sentences very, very carefully so that you understand the meaning. Person who is making the proposal, his name is promisor. Person who is accepting the proposal, his name is called as promisee. Now all these terms and conditions have to be accepted very, very carefully and clearly by you, because while writing these terms and conditions in the examination, all these definitions when you are writing, you will not be allowed to write on your own terms. You have to follow exactly what has been prescribed by the law. Now, moving further, let's try to understand one more definition called as consideration. Now, what does the word consideration mean? Normally, in English, when we use this word consideration, we might be trying to express the factor, why don't you even look into this? That is what we are trying to say. But then when it comes to the context of law, let us try to understand the definition. When at the desire of the promisor, I am the promisor here, when at the desire of the promisor, the promisee or any other has done or abstained from doing what he does, or from doing or promises to do or abstain from doing something, such act or abstinence or promise is considered to be consideration for the promise. Which means to say that when the promisor, at the desire of the promisor, you are able to understand, accept, consider what has been told from doing, from particularly executing that proposal, the order, the contract altogether, we call it as consideration altogether, and that is given in the section 2D. Now, contract. Now, what is this contract? Now, we are going to come to the real meaning of the contract. An agreement enforceable by law is a contract. Very, very important question and a definition which you have to learn in this subject as per section 2H. You need to understand any agreement, an agreement which is enforceable by law is called as contract. So let me make it simple for you. Contract is equal to agreement plus enforceability by law, which means now law comes into picture. Unless and until it is enforced by law, agreed by law, by the terms and conditions set, then only it becomes a contract, or else it's just an understanding. It is just only a give and take policy. Only when you are making the agreement enforceable by law, then it becomes a contract. So when you sign an house rental agreement or when you sign a work agreement, that means it is enforceable by the court of law. So that is why it becomes a contract. Now, the most important thing that we need to understand here is that contract is subjected to law, which means in case if you are not following the rules and regulation, if you are not enacting as per what is prescribed on the document, then it is definite, or then it is sure that you will be facing the court, you will be facing the action that is being recommended by law. So it is very, very important. Once you have signed on the contract agreement, you need to exactly follow what has been mentioned. Moving forward, essentials of a valid contract. Now, this is a very big question. This is a very big part. So we are going to see it part by part. We are going to take it forward so that you are able to understand it. So there are 10 factors under the essentials of valid contract. Let us go one by one so that you understand the entire scenario. The first one is agreement, where we talk about offer and acceptance. So we had spoken about it. When I offer you and when you agree to it, it becomes an acceptance, and then we form an agreement. So that is what we call it here as agreement, followed by legal purpose. So there is some legality involved in this. It is not just a paper, it's not just a document where I write something and you agree, but it is enforced by the law. So that's why it is for legal purpose. Second, lawful consideration. There is something which is involved which has a lawful consideration that is very much under the purview of law. We are not going to put an agreement for something doing illegal or out of the context or against the society. So this is something which is a lawful consideration, very much that comes under the purview of law. followed by capacity to contract. Do we have the capacity, the person, that is the promisor and promisee, do they have the capacity, do they have the capability to follow the contract? That we are going to look. Free consent, which means you are not subjected to any pressure. You will be able to follow the contract at your will and wish. Nobody can force you to do it. Followed by lawful object. Whatever that has been put is very much under the lawful condition. You are not going to talk something which is abstract, which is out of the context. Certainty. When we talk about any agreement, any contract, that has to be certain, definitive, quantitative in nature, and not something where we are just going to talk something like out of the moon, out of the sky, all kind of things. It is something certain which has to be executed at the time and at the date that is being given. Possibility of performance. Is it possible enough to first of all go through the contract and execute it? Are you just doing a contract because somebody has told you to do, or are you doing a contract because there is a practical factor behind it? So you have to see the practicality of the contract, whether executable or non-executable, followed by not expressively declared void. So it is not something which is already been declared void, it's something which can be done. And the legal formalities, as I've always told you, when it comes to that of the legality, that is the contract part, every single word that is being mentioned in the document are subjected to the court of law. So every word has to be read, understood thoroughly, and then you need to sign on the contract. Now, moving further, let's start with the agreement factor. Offer and acceptance. There must be a lawful offer by one party and a lawful acceptance by the other party, which means whatever I am offering to you must be legal in nature. I should not offer you something which is illegal or against the society, against the norms of the business. So whatever I am offering to you as a business solution should be legal, and the person who is accepting it must also be in the position to take it, followed by the legal purpose. The parties to an agreement must create a legal relationship. So that means the promisor and promisee should create a legal relationship here, and they should say that it is primarily for a business purpose and we should not try to bring in any other factors. So agreements of social domestic nature do not create a legal relation, and that is why I say that this is not something based on friendship. This is not something based on relations. This is not based on something just because we know each other. The contract means that there is something which is definitive in nature and it is being created according to the law. So you should not mix any social or domestic purposes and start solving it. Now, moving further, I'm giving you an example here. X invited Y to a dinner. Y accepted the invitation. It is purely a social agreement. Now, there are no hard and fast rule that yes, I have to come to the dinner. If I miss out on the dinner, then that's going to be a legal penalty. Absolutely not. X has invited Y for a dinner and Y has accepted it. It's a social agreement. If X fails to serve dinner to Y, or Y does not come to the dinner. Now, in both of the case, X or Y cannot go to the court and start claiming anything about it. So that's where I'm trying to say that because there is no law enforcement here, there is no legality that is involved. If X does not serve the dinner or Y does not come for the dinner, there is absolutely not going to be any legal enforcement. So that means this is purely a social agreement, a friendly agreement. That's all. It's on a request, it's on an invitation, so you cannot enforce it by law. With this, I come to the conclusion of the first session. In the upcoming session, we are going to speak about more on the essentials of valid contract. I hope and believe whatever has been shared to you through this particular session will be of a great help and resource to you. Coming forward to the next session, until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.